A very warm greetings and welcome to Law and Life. I'm Shashank Mishra, the Senior Advocate of Supreme Court of India, Subodh Markandiji. This is a channel initiative by Sir to discuss and aware about ongoing legal issues, laws, statutes, and other associated things. Likewise, topic of today's episode is controversial appointment of Justice L.Victoria Gauri as Judge of Madras High Court. So starting with my first question, is it per se wrong to appoint person with a political background as a justice of constitutional courts? Have such person been in the past appointed as a judge of High Court and Supreme Court?
Shashank, your question is in two parts. So
Yes, sir.
I'll answer the second part first. That is, I'll give the names of persons who were actually political, politically active persons, and they were all raised to the bench of the High Court, and then went on to become the judges of the Supreme Court. So
Yes, sir.
uh, there is nothing in Article 124 or 217 which respectively deal with the appointment of Supreme Court judges and High Court judges to debar any political functionary from being appointed as a judge. So the first person with political background known to me who was appointed as the judge of the Andhra Pradesh High Court was Mr. Gopal Rao Ekbote. In the first general elections which were held in 1952, after the constitution came into force, he was elected as a member of the Legislative Assembly of the then state of Hyderabad on the ticket of the Indian National Congress. So he became a minister for education, law, and local bodies in the first elected cabinet, which was headed by a very eminent lawyer called Dr. Burugula Ramakrishna Rao. He was in those days doctorate in law. But after states were reorganized, in 1956, Mr. Akbote chose to be in the state of Andhra Pradesh. He did not go to the state of Bombay, as it was called, now Maharashtra. Although he was Marathi speaking person, he chose to remain in Hyderabad because he had deep roots there and very flourishing practice. So
Yes, sir.
he was raised to the bench of Andhra Pradesh High Court, and he was a very, very astute and very uh, able judge, uh, some kind of, Supreme Court material. Of
Yes, sir.
course, all of them can't make it to the Supreme Court, but he was very, very well grounded in law. The second person whom I know was the celebrated judge of the Supreme Court, Mr. V.R. Krishna Iyer. So he contested second general elections in 1957 as an independent candidate in a Kerala Legislative Assembly, and he was elected. And in the first elected communist government under very famous leader called EMS Nambudripad, who was the chief minister, Mr. V.R. Krishna Iyer became a minister for education, law, and prisons. He later became the judge of the Kerala High Court and was raised to the Supreme Court bench. And as you know, he was the most acclaimed Supreme Court judge. Then,
Yes, sir.
when I came to Allahabad and practiced under Mr. Jagdish Swarup, I came to know that Mr. Shivnath Kajju uh, was a member of Uttar Pradesh Legislative Assembly in 1952 to 57, and he was also a member of the Legislative Council in 1958 to 1962. And he was later, when I joined the bar, he was appointed as the judge of the Allahabad High Court. Then we have very famous judge of the Supreme Court, Mr. K.S. Hegde. He was a Congress member of the Rajya Sabha in 1957 to 1962 and was appointed as the judge of the High Court of Mysore, now called Karnataka. and he was the first Chief Justice of Delhi High Court, and later on also raised to the Supreme Court bench. He, along with two other judges, were superseded, and then he became a member of the Lok Sabha uh, in I think 1977, and he also served as the Speaker of Lok Sabha. Then Mr. Ratnavel Pandian was a district secretary of Dravida Munditra Kadagam, and he contested for MLA's post. I'm not sure whether he was elected or not. But later on, he was raised to the bench of the Madras High Court, and then he also became a judge of the Supreme Court. Then Mr. Baharul Islam was elected to Rajya Sabha in 1962 and 1968, and was later appointed as the judge of the Guwahati High Court. And then he retired as the judge of the Guwahati High Court. But after retirement, he was raised to the Supreme Court bench, and he served for some time. In recent times, we know that Mr. Jasti Chalameshwar and Chief Justice of India, Mr. N.V. Ramanna, before becoming judges of the Andhra Pradesh High Court, they were respectively, they belonged to Communist Party of India and the Telugu Desam Party. In a parliamentary democracy, we cannot bar the political functionaries from being appointed as the judges of the Constitutional Court. They have very wide experience on the legislative side, which is very valuable.
Sir, on what ground did any Matthew and other challenge the appointment of Justice L.Victoria Gauri as a judge, High Court of Madras?
Shashank, I did not have the benefit of reading the writ petitions under Article 32, which were
Yes, sir.
filed by Anna Matthew and I think three others. There were four petitioners before the Supreme Court uh, who challenged the appointment of Justice L.Victoria Gauri as the judge of the High Court of Madras. But as gleaned from the judgment of the Supreme Court, dated 10/2/2023, in writ petitions number 147 and 148 of 2023, that is titled as Anna Matthew and others versus Supreme Court of India and others. I think these were the grounds. The appointee, that is Mrs. L.Victoria Gauri, is a person of strong political background. I think from her youth, she was a member of BJP, Bharatiya Janata Party. And the second point was that the appointee has expressed very strong views about certain matters, which according to the petition, render her unfit to be appointed as the judge of the Madras High Court. And thirdly, they relied upon a case, which is the only single case in which, after the president issued the warrant of appointment, that warrant of appointment was quashed. So that's the case of Kumar Padma Prasad versus Union of India, 1992, 2 SCC 428. That's the only case in which the Supreme Court quashed the warrant of appointment of a High Court judge. So he never took oath because of it was quashed.
Yes, sir. And sir, and what about the did Supreme Court of India hold?
So Supreme Court of India, while dismissing these two writ petitions under Article 32, they held that grounds which have been raised in the writ petitions are all covered by the Supreme Court judgments, earlier judgments. Therefore, the question which they have raised is no longer res integra. And so these are the cases on which the judges relied upon. First case is Supreme Court AOR Association versus Union of India, that is reported in 1993 4 SCC 441. That's a 9 judges bench. So the reliance has been placed on paragraphs 480 to 482. Then the second case is a 5 judge bench judgment in the case called in re special reference number 1 of 1998, and that has been reported in 1998 7 SCC 739. The third case on which they have relied upon is Mahesh Chandra Gupta versus Union of India, 2009 8 SCC 273. They have relied on paragraph 77. And the last case on which they have relied is M. Manohar Reddy versus Union of India, 2013 3 SCC, page 99. So these cases have laid down, number one, the appointment of a judge is an executive function of the President of India. The second point which they have decided is that Article 217, Clause 1 prescribes the constitutional function of consultation, which evaluates the fitness of a person to be appointed as a judge of the High Court. That is, her worth, her merit, her character, her integrity, her competence and knowledge. And this is quite entirely different from her eligibility, which has been laid down in Article 217, Clause 2. And that is the threshold limit or eligibility or entry point for a person to be qualified as a judge of the Supreme Court. The third point which they have decided is that while eligibility is determined by objective factors, applying the parameters and qualifications laid down in Article 217.2, fitness to be appointed as a judge essentially involves the aspect of suitability determined by two collegiums, that is the collegium which recommends, that is in the High Court, and the collegium which makes recommendation to the President for appointment, that is the Supreme Court. And that being so, judicial review is barred because two collegia, of which chief justices are they preside over those collegia. So it's not again, necessary to subject such appointment to judicial review. That is to say, in other words, judicial review is restricted only to two areas. That is to say, eligibility and whether there has been effective consultation. If there is no eligibility or if there is no effective consultation, then, it can be subjected to judicial review, not otherwise. So judicial review of fitness is excluded because the selection itself is based on the plurality of views of two collegiums, that is 6 judges, 3 of High Court and 3 of Supreme Court, including 2 Chief Justices of High Court and Supreme Court. Now, when such an appointment is made, it can't again be subjected to judicial review. That's the reasoning. And it is also, that is because it's an adequate safeguard against any arbitrariness or bias. So, during the course of hearing, the court noted that the petitioners have themselves accepted that a number of persons of political backgrounds have been elevated to the High Courts and the Supreme Court benches. I have also enumerated some of them. So these persons are recommended for elevation. Some of the persons who were recommended for elevation had expressed strong views criticizing the policies and actions of the government. So, expression of views cannot be held out against a candidate and debar him or her from being appointed. So, the court held that these are considerations which do not lay down absolute bar to make such persons unsuitable for appointments. Of course, they are relevant factors to be considered. If after considering them, the court comes to the conclusion that they are still independent and fit persons to be appointed, then the courts, the collegia recommend them. The conduct of judges, after he or she is appointed, must reflect and show independence and adherence to the constitutional and democratic values set out in the constitution. Because the judiciary in our country holds center stage in protecting and strengthening democracy and upholding human rights and the rule of law. See, very strong reliance was placed by the petitioners on a case called Sri Kumar Padma Prasad versus Union of India, to which I have already made a reference earlier. That
Yes,
was
sir.
a case in which a person in whose favor warrant of appointment as a judge of the High Court of Guwahati was issued, but he was not qualified. There were, charges of corruption against him. So, uh, so the power of judicial review was exercised, and uh, that warrant of appointment was quashed. Since the petitioners, expressed apprehension uh, about the candidate, about the appointee, that is now Justice L.Victoria Gauri, they made a lot of apprehensions about her suitability. So they, of course, suitability is not that's a different question, but they also pointed out this, that she has only been appointed, for 2 years as an additional judge. And on taking oath, she pledges, to uphold the constitution and the laws. Then court also uh, referred to Article 51 capital A, which casts an obligation on every citizen and more so on every judge to promote harmony, spirit of brotherhood amongst all, transcending all religious, linguistic, regional, and sectional diversities. So the principles of secularism and dignity of every individual, regardless of religion, caste, or creed, is the foundation of rule of law and equal protection of laws. So the court held that the apprehensions were, they did not hold as such in so many words, but in a way they held that the foundation, that the apprehensions about the suitability of Justice Victoria Gauri are not well founded. Not only the conduct, and so these are the words used, this is the reasoning. Not only the conduct and judgments delivered by the judge concerned are considered at the time of confirmation after 2 years, but every day the judge is judged by lawyers, litigants, and public at large. Courts are, after all, open, and judges speak through their judgments, giving reasons for their judgments. So they are all subject matter of scrutiny. So in the result, since the matter was already decided, so the court dismissed the writ petitions.
Yes, sir. Yes, sir. With that, we will end the beautiful session with you. Thank you, sir, for giving your time, and we will see you in the next episode, sir.
Thank you, Shashan.
Thank you, sir.